This is Colin O'Keefe for LXBN TV, and my guest today is Andrew Trask of McGuire Woods and of one of my favorite class action blogs on the Lex Blog Network, Class Action Countermeasures. Today we're discussing two of the top class action cases of 2011 as we kind of do a bit of looking back at the past year, those two cases being the much discussed Wal-Mart v. Dukes and AT&T Mobility v. Concepcion. Skipping over the details, Andrew, what are the main points that we can extract from these two cases? What are the primary outcomes?
Let's see. Skipping over all of the details, I think there's one very large point, and that's one that Judge Easterbrook actually mentioned in his case on aqueducts recently, and that is that Rule 23 says what it says. You depart from it at your peril. And so if you try to add extra requirements or subtract out a requirement for some reason, you're likely to get overturned at some point. That said, there are probably three major points you can pull out of the two cases. The first is that the commonality requirement of Rule 23A2 is not meaningless. I think up until 2011, a lot of courts sort of treated it as something that needed to be checked off, but didn't need to be examined. And I think Wal-Mart has changed that. The second thing is that Rule 23B, which is the second part of the rule, is divided into three sections for a reason. I think that what the plaintiffs have been trying to do in Wal-Mart v. Dukes was to take the label for one section of Rule 23B and apply it to a case that clearly fit into another section in order to ease certification, which was a good thing for them to get. They weren't able to do that. The court has basically said, no, we've divided this rule into three sections for a reason. If you're seeking monetary damages, you have to go under Section 23B3. If you're looking for injunctive relief, that's 23B2. But let's not play games about dividing those up. And the third thing, I think, which is the main point of Concepcion, is that class action lawyers can't ignore their members' contracts. If you've got a class action that's based on a contract, you have to pay attention to all of the terms. And that means that if there is an arbitration clause in there, that's something that you have to take account of.
That makes sense. That makes sense. And, I've seen, not only have these two cases have been discussed a lot recently, but we've also seen them coming up in other cases, of course, and having an impact in other litigation. Which of these two do you think had a bigger impact in 2011?
In 2011, I think the answer is pretty clearly Concepcion. And the reason I say that is because there were more cases that were waiting for resolution pending that opinion coming out. Just the number of cases that have been brought in, or number of class actions that have been filed in different areas where there was an arbitration clause, probably numbered into the hundreds by the time we were done. And so if you look over the opinions that were published in 2011, a number of them pick up some of the standards from Dukes, but some of them are just doing that as the latest Supreme Court case on class actions, and it didn't really change the outcome of those cases. Concepcion, at least in 2011, changed the outcome of more cases. So I think it had the larger impact so far. Going forward, it's anyone's guess. I'm really interested to read the opinions in 2012.
It'll be interesting to watch. And then, a lot of the criticism for these two rulings goes around the idea that one of these two cases, or that these cases killed the class action lawsuit. Do you think either of these two cases truly killed the class action lawsuit or had this, profound detrimental impact on future class actions?
I really don't. I would actually say the answer to that is a very clear no. I'm not even sure they winged it all that much. As a test of that, by the way, before I got online, I did a very quick Google search for the terms announce, class action, and filing, which is something that I get a lot of in my Google feed over the days. And I limited the search to the last 24 hours. I got 43,700 results. Now, obviously, not all of those are actually specifically an announcement of a class action filing in the last 24 hours. Some of them are articles, some of them are reprints of press releases, some of them go back a little bit further. But it's very clear that plaintiffs have not stopped filing class actions because of these two cases. Moreover, I think what the two cases have done really is to restore some of the strategic balance between class action lawyers and class action defense lawyers. And what I mean by that is I think up until these two cases came out, it was somewhat easier than it had been historically to file class actions and to get some kind of response out of defendants more than just a motion to dismiss. Dan Gerard of Gerard and Gibbs, which is a very well-known and very reputable plaintiffs firm, said something at a conference about 3 or 4 weeks ago in the Netherlands, which is that the class action isn't dead, but it may be the golden age of the private attorney general is over. And I think that may be what these cases have really done. To the extent that it was very easy for plaintiffs to file class actions regardless of their merit. I think it's become a little bit harder. But I don't think that meritorious class actions have really been harmed by these two opinions. And to take a very brief example of what I mean by that, if you look back at 2010, actually, there was a case called Brown versus R.J. Reynolds. It was a Florida class action having to do with tobacco, and it was certified in the Florida state courts despite the fact that there were a number of problems that the defendants had raised with certification. One of those, by the way, had to do with commonality. The defendants basically came out and said, look, there's no common question here. And the way that Dukes has now defined that, a common question needs a common answer. So the common question isn't just, is everybody a plaintiff? It has to be, was everybody harmed in the same way? The Florida state court certified the class action, spent 14 months on a trial, what they called a phase 1 trial of 3 phases, and then released everybody to do phase 2 trials on their own. In other words, they went and did a trial on the common question. And the common question there was pretty abstract. The common question was, have the defendant cigarette companies, and I think there were 7 of them, ever lied at any time in any way about tobacco products? And the answer came back a resounding yes. But when everybody tried to take those to their phase 2 trials, what they discovered was the answer, this tobacco company may have lied at some point in the past about its tobacco products, did nothing to help them prove their individual claims. And so they wound up having to start from ground zero. The end result was 14 months of trial and however many months of trial preparation before it were basically wasted. And that's not what we want for either side in litigation. We don't want plaintiffs to have to go through 14 months of litigation to find out that their claims are right back at ground zero again. We want them to be able at each step to take them forward if they're going to win them. And if it's very obvious at a given point that they don't have what it takes, we'd like to end the litigation there so they can get on with the rest of their lives. In that sense, I think it's really important that people recognize that tightening the requirements doesn't necessarily mean harming the class action. Frequently, it actually means helping it by restoring its legitimacy and by making it the tool for efficiency and justice that it's supposed to be in the first place.
That makes sense. You don't want to lead people down a path that's ultimately going to be a dead end anyway.
Precisely.
Perfect. Thanks for your time. Once again, that's Andrew Trask of McGuire Woods and on class action countermeasures. If you haven't seen it, be sure to check it out. It's one of my favorite class action blogs on the network. Once again, classactioncountermeasures.com. And of course, for more on these two cases, there's a lot going back. Be sure to check out lxbn.lexblog.com as well. Thanks again, Andrew.
Thank you, Colin.